Judge Christina Baca was 3 miles from her Broward County home when Sheriff Robbie Schwartz's patrol lights appeared in her rearview mirror. She hadn't been speeding. She hadn't drifted a lane. She hadn't committed a single moving violation. She was a sitting Florida Circuit Court judge, and she was about to become the target of the exact kind of pretextual stop she had spent 17 years dismantling from the bench. What Schwartz didn't know was that 4 cameras were already capturing every move he made. The woman he was pulling over had the authority to void law enforcement careers with a single signed order. She had personally presided over 23 cases that had collapsed corrupt police units across the state of Florida. And the stop he was about to conduct, fabricated on the thinnest pretext in Broward County history, would trigger a $40 million federal lawsuit, expose 847 illegal traffic stops, end his career in disgrace, and result in the largest law enforcement accountability mandate in Florida history. If you're ready to see how one woman, composed, credentialed, and completely unintimidated, used nothing but evidence and silence to dismantle a corrupt system from the inside out, hit that like button right now and drop a comment telling me where you're watching from. And if this is your first time here, subscribe immediately, because tomorrow we have another story of someone who picked the absolute wrong person to cross. Let's get into it. Judge Christina Baca was 44 years old on the afternoon Robbie Schwartz made the worst decision of his professional life. She had graduated in the top 3% of her class from Florida A&M University College of Law, the same institution that had produced some of Florida's most formidable civil rights attorneys. She had spent 9 years as a state prosecutor, building a record that included successful convictions on public corruption, organized crime, and law enforcement misconduct cases. At 38, she had been appointed to the Broward County Circuit Court, becoming the youngest black woman ever to hold that seat in the county's history. Her confirmation had been unanimous. In 17 years on the bench, Judge Baca had issued rulings that set precedent across 3 judicial districts. She had the authority to issue warrants, suppress evidence, overturn convictions, and, when the facts demanded it, disqualify law enforcement officers from ever testifying in a Florida courtroom again. She had done all of these things, more than once. On this particular Tuesday afternoon in September, Baca was driving home from a sentencing hearing, her 3rd of the day. Her vehicle was a white Mercedes S-Class, purchased outright after years of disciplined saving on a circuit judge's salary. Florida plates, fully registered, fully insured, and completely clean in every law enforcement database in the state. She wore a tailored navy blazer, a pearl necklace, and small pearl stud earrings, the same composed, professional presentation she brought to the courtroom every morning. Her judicial ID wallet sat in her purse on the passenger seat, beside her phone, which was connected to the Bluetooth mount on the dashboard. She was mentally reviewing her evening schedule, thinking about a case brief she needed to finish before morning, when the blue and red lights materialized in her rearview mirror. That was the moment Sheriff Robbie Schwartz of Broward County decided to pull her over. Baca signaled immediately, smoothly, and pulled into the parking lane of a quiet suburban boulevard. Composure intact, hands deliberate. She placed both hands on the steering wheel at 10 and 2 and waited. Her dashboard camera activated automatically, a standard precaution she had installed 2 years earlier after a colleague on the bench had received a credible threat from a defendant. The lens captured everything forward-facing with high-definition clarity and embedded timestamps. Schwartz approached her driver's side window with the particular posture Baca had seen documented in hundreds of civil rights case files, shoulders squared at an angle that broadcast authority assumed rather than earned, one hand drifting near his service weapon with practiced casualness. His jaw already set in the expression of a man who had already reached his conclusions before asking a single question. He wore no visible body camera. He demanded her license and registration without greeting, without explanation, without pause. Baca's voice carried the same measured, unhurried authority she used to manage contentious attorneys in her courtroom. She asked, clearly and without hostility, why she had been stopped. Schwartz's answer came without hesitation. Reports of a stolen white Mercedes in the area. Her vehicle matched the description. Baca's legal training engaged instantly and automatically, the same reflex that had made her one of the most methodical judges on the circuit. Stolen vehicle reports were dispatched, time-stamped, and logged in real time through county systems that could be verified in under 30 seconds. The claim was either documented or it was fabricated. There was no third option. She asked, calmly, for the report number. Schwartz's jaw tightened. He repeated his demand for her license and registration. His voice had dropped a register, harder now, carrying the edge of a man unaccustomed to being questioned. Baca announced each movement before she made it, reaching for her purse, opening the zipper, withdrawing her wallet. Her fingers found two items, her Florida driver's license and her Broward County Circuit Court judicial identification card. She extended both through the window. The judicial credential was unmistakable to anyone in Florida law enforcement. Official seal of the 17th Judicial Circuit of Florida embossed in raised gold. Her full name, Christina Marie Baca. Title, Circuit Court Judge, 17th Judicial Circuit. Full-color photograph. Appointment date. Security verification strip along the lower edge. It was the kind of identification that officers in her jurisdiction were trained to recognize. Schwartz looked at the credentials for approximately 5 seconds. His expression did not shift. Not surprise, not recognition, not recalibration. The skepticism held firm. The hostility held firm. He handed both documents back through the window as if they were inconclusive, and told her, with finality, to step out of the vehicle. Something cold and clarifying settled in Baca's chest. She had spent 17 years on the bench. She had reviewed hundreds of depositions from black drivers describing this precise sequence. The fabricated pretext, the dismissal of identification, the order to exit as a dominance maneuver when the initial premise began to collapse. She had read the affidavits. She had cross-examined the officers. She had ruled on the evidence. She had simply never been the one sitting in the car. She stated, in clear, measured language, that her credentials had been issued by the state of Florida and were verifiable through multiple official channels within 60 seconds. Her vehicle registration was current and legitimate. No lawful basis for the stop had been articulated, and no lawful basis for her removal from the vehicle existed. She was invoking her right to remain inside. Schwartz's response was a command. Step out of the vehicle. Do not make him repeat it. What neither of them had fully accounted for was this. They were being recorded from 4 different angles simultaneously. Baca's dashboard camera had been running from the moment Schwartz's lights appeared. 40 feet away, the exterior security system of a neighborhood bank monitored the parking lane from 2 elevated positions, both cameras covering overlapping sight lines with synchronized timestamps accurate to the 10th of a second. And on the sidewalk across the street, a woman named Darlene Marsh had been walking her dog when she noticed the officer's posture. Aggressive, hands near weapon, toward a visibly composed woman in a business suit sitting calmly behind a steering wheel. Darlene had stopped walking. She had raised her phone. She had pressed record, zoomed in, and held very still. Baca complied with the order. She opened her door slowly, stepped out with deliberate control, and stood beside her Mercedes with both hands visible at her sides. Her mind was already documenting with the precision that had defined her entire legal career. Time, 4:12 p.m. Location, Palmetto Park Road, Broward County. Vehicle, legally registered, plates visible and clean. Witnesses, bank customers visible through the window to her left, a pedestrian with a phone across the street, 2 passing vehicles that had slowed. Credentials. Presented and dismissed without verification attempt. Schwartz radioed for backup. His voice across the open frequency was bureaucratic, professional, and completely disconnected from what was actually happening in front of him. Suspicious vehicle stop. Subject claiming to be a judge. Unable to provide a satisfactory explanation for the vehicle. Baca's correction was immediate, precise, and captured in full audio by all 4 cameras. She had provided complete judicial identification. She had not been asked to explain her vehicle. Florida judicial salaries were public record, and no verification of her credentials had been attempted through any official channel. Deputy Marcus Teller arrived in under 8 minutes, younger than Schwartz by what appeared to be 15 years, visibly uncertain, deferring immediately to the senior officer's framing of the situation. Schwartz briefed him quickly. Suspicious stop. Subject being uncooperative. He was going to search the vehicle. Baca's response was delivered in the same tone she used when attorneys attempted to introduce inadmissible evidence in her courtroom. Firm, direct, and leaving no interpretive room whatsoever. She did not consent to any search. No probable cause had been articulated that would survive a first-year law student's scrutiny. Her judicial credentials established her identity beyond any reasonable question. The stop itself was unlawful, and any search conducted under these circumstances would constitute a clear violation of her Fourth Amendment rights, one that would be documented, time-stamped, and fully admissible in federal court. Schwartz did not respond to the legal argument. He turned toward her vehicle. He opened the driver's door. On the passenger seat sat her purse, her phone charging cable, and a sealed manila folder bearing the header of the 17th Judicial Circuit, case materials for the following morning's docket, protected under Florida court seal. Beside it, clearly visible, was a bound case review file marked with a bright orange cover sheet, stamped in block letters. Confidential court record. Unauthorized disclosure prohibited under FS Section 119.071. Baca's voice carried the full weight of 17 years on the bench. That file contained sealed court records under active judicial protection. Accessing it without authorization constituted a violation of Florida statute and a direct contempt of circuit court order. She was, as a sitting circuit judge with direct jurisdiction, ordering him to stop immediately. Schwartz reached for the file. Teller's hand moved to his partner's arm. A hesitation, brief and instinctive. The stamps looked official. The language looked real. Maybe they should call a supervisor first. Schwartz pulled the file from the seat. And Judge Christina Baca, standing handcuffed beside a patrol vehicle on a Tuesday afternoon in Broward County, looked directly into the lens of Darlene Marsh's phone camera across the street, and said, quietly and with absolute certainty, "You boys are done." She was right. Robbie Schwartz had worked the same 12-mile stretch of Broward County for 11 years, and he knew every car that belonged there. That was how he would have described it if anyone had asked. Not profiling. Recognition. Pattern familiarity. The instinct of a man who knew his territory. The driveways, the routines, the faces behind the windshields of the vehicles that moved through these particular streets at this particular hour. He knew which cars belonged, and he knew with a certainty he never examined too closely which ones didn't. The white Mercedes appeared in his peripheral vision at 4:09 p.m., heading westbound on Palmetto Park Road at a lawful speed, fully within its lane, signaling correctly at the intersection. Nothing about its movement gave him cause. Nothing about its condition gave him cause. The plates were clean Florida registration, current tags, no flags, no holds, no alerts of any kind. The vehicle came back immediately in the system, registered, insured, and entirely unremarkable by every measurable legal standard available to him. Schwartz ran the plates a second time. Clean again. He sat with that for a moment, his patrol unit idling at the intersection, watching the Mercedes continue westbound at 32 miles per hour in a 35 zone. Through his windshield he could see the driver, a black woman, alone in a dark blazer, hands on the wheel, posture unhurried. She was not on her phone. She was not erratic. She was not doing anything that constituted a traffic violation under any statute he could name. He pulled out anyway. He closed the distance over 4 blocks, running the plates a third time out of habit or hope. It would be difficult afterward to determine which, and when the system returned the same clean result for the third consecutive time, he reached up and activated his lights. The Mercedes signaled immediately, smoothly, and eased into the parking lane without hesitation. Cooperative, deliberate, the behavior of someone with nothing to hide and every reason to be exactly where she was. Schwartz did not register any of that. He was already reaching for his door handle. He had already decided. Christina Baca had presented identification to law enforcement exactly once before in her adult life. A routine license check during a traffic stop 15 years earlier, 3 months after she had passed the bar. She remembered thinking, even then, how carefully she moved, how deliberately she announced each gesture, how conscious she was of the space between her hands and her purse, between her purse and the officer's perception of threat. Nothing had changed. If anything, she was more precise now. She announced that she was reaching for her purse. She announced that she was opening it. She withdrew her wallet with 2 fingers and extracted both documents in a single, unhurried motion. Her Florida driver's license and her Broward County Circuit Court judicial identification, and extended them through the open window without being asked twice. The judicial credential was not subtle. It was not the kind of document that invited ambiguity. The raised gold seal of the 17th Judicial Circuit sat embossed at the upper left corner. Her photograph was centered, clear, and current. Her full name ran beneath it in official type, Christina Marie Baca. Below that, her title, Circuit Court Judge, 17th Judicial Circuit, State of Florida. The appointment seal, the verification strip, the issuing authority. Everything that distinguished it from any document a person could fabricate was present, visible, and unmistakable to anyone with a working familiarity with Florida law enforcement credentials. Schwartz took both documents. He looked at the judicial ID for 5 seconds. She counted, with the expression of a man reviewing something he had already dismissed before he read it. There was no pause of recognition, no shift in posture, no reaching for his radio to run a verification through the circuit court system, which would have taken less time than it took him to hand the credentials back. He handed them back through the window, both of them, without a word about what he had just seen. And then he told her to step out of the vehicle. Baca looked at him for one measured moment. 17 years of courtroom discipline held everything steady behind her eyes. The anger, the recognition, the cold clarity of understanding exactly what was happening and exactly what it would cost him. She asked him why. He said it again. Step out. Now. What Robbie Schwartz had never once considered, in 11 years of working the same 12-mile stretch of Broward County, was that the street watched back. Baca's dashboard camera had been running since the moment his lights appeared in her rearview mirror. She had installed it 2 years prior on the recommendation of the Broward County Judicial Security Office, a standard precaution for circuit judges whose dockets included organized crime and law enforcement misconduct cases. The lens was wide-angle, high-definition, and embedded with a GPS timestamp accurate to the second. It had captured Schwartz's approach, his posture, his hand position near his weapon, and every word exchanged through the driver's side window in uncompressed digital audio. That was one. 40 feet north, mounted at opposing angles above the entrance of a Sunoco station, 2 exterior security cameras covered the full length of the parking lane where Baca had pulled over. Their fields of view overlapped at precisely the point where Schwartz was standing. Their timestamps were synchronized automatically to a central server. The station manager, a retired Dade County Corrections officer named Gerald Okafor, would later tell investigators he had noticed the stop within 90 seconds and had personally confirmed the recording system was functioning before going back inside. That was 3. And on the sidewalk across the street, Darlene Marsh had stopped walking her dog at the precise moment something about the officer's posture struck her as wrong. The way his shoulders were set, the way his hand moved, the way the woman in the navy blazer was sitting so carefully still. Darlene was a registered nurse. She had spent 22 years reading body language in high-pressure environments. She raised her phone, zoomed in, steadied her grip against her collarbone, and held the frame without moving for the next 11 minutes. That was 4. What made it 5 was Schwartz himself. In the procedural momentum of the stop, in the absolute confidence of a man who had conducted hundreds of these encounters without consequence, he had forgotten to disable his department-issued body camera. It had been recorded from the moment he stepped out of his patrol unit, including the moment he radioed dispatch and described, in calm professional language, a suspicious vehicle stop involving a subject unable to explain her luxury vehicle. A claim every single camera on that street had just recorded him inventing. The Broward County Sheriff's substation on Palmetto Park Road had the particular stillness of a Tuesday afternoon. 2 deputies at their desks, a civilian administrator sorting paperwork, and Desk Sergeant Paul Arredondo working through an incident log with the unhurried rhythm of a man 4 years from retirement. Nothing about the shift had suggested it would become the most consequential of his career. Baca walked in ahead of Schwartz with the composed, forward-facing posture of a woman who had spent 17 years entering rooms where the power was supposed to belong to someone else. Her wrists were no longer cuffed. Schwartz had removed them in the parking lot outside, a belated calculation that had come approximately 43 minutes too late. She had not rubbed her wrists. She had not adjusted her blazer. She had simply walked toward the front desk and stopped directly in front of Sergeant Arredondo with both hands resting on the counter. She did not raise her voice. She did not need to. She told Arredondo her name, her title, and her judicial circuit. She told him she had been unlawfully detained without probable cause, that her vehicle had been searched without consent, and that she was now standing in his lobby as a direct consequence of a fabricated radio report that had been filed by the officer standing 6 feet behind her. She said all of this with the even, unhurried cadence of someone reading findings into the record. Arredondo looked at Schwartz. Schwartz said nothing useful. Baca set her phone on the counter and turned the screen to face the sergeant. She had already pulled up all 4 feeds, her dash cam footage, the Sunoco station angles, and Darlene Marsh's 11-minute recording, cued, timestamped, and synchronized. She let Arredondo watch for 90 seconds without comment. Long enough to reach the moment Schwartz's voice came clearly through the audio describing a subject unable to explain her luxury vehicle. Then she picked her phone back up. She told him she would be contacting the Florida Bar, the Broward County State Attorney's Office, and the Chief Judge of the 17th Circuit within the hour. She told him the footage would be in the hands of every major news desk in Florida shortly after that. She looked at him steadily and said he had approximately 30 minutes. Then she sat down in the waiting area, crossed her ankles and waited, as composed and immovable as she was every morning on the bench. Christina Baca did not sleep that night. Not because she was shaken, though she was in the particular way that only becomes fully visible in the quiet of an empty house, but because she had work to do. By 9 p.m. she had reached her lead attorney, Diane Osei, a civil rights litigator out of Miami whose name appeared on 6 of the most significant law enforcement accountability verdicts in Florida's recent legal history. By 11 p.m., Osei had contacted 2 co-counsels. By midnight, all 3 were on a call with Baca at her kitchen table, working through a timeline she had already reconstructed from memory with the methodical precision of someone who had spent 17 years writing findings of fact. The complaint they filed 41 hours later was 94 pages long. It is named Robbie Schwartz individually. It was named the Broward County Sheriff's Office institutionally. It cited violations of the Fourth Amendment, the 14th Amendment, 42 U.S.C. Section 1983, and Florida's civil rights statutes. It documented the fabricated stolen vehicle report, the dismissal of judicial credentials without verification, the warrantless vehicle search, the seizure of protected court documents, and the unlawful detention of a sitting circuit court judge, each allegation supported not by assertion, but by evidence. The footage from all 4 cameras had been forensically preserved within hours of the incident. Every frame was time-stamped. Every audio exchange was transcribed and cross-referenced against Schwartz's official radio log, which the complaint reproduced in full, alongside a side-by-side comparison demonstrating, in language that required no legal training to understand, that the report he had filed bore no relationship to the events any of the 4 cameras had recorded. The damages sought totaled $40 million. The filing landed on the docket of the United States District Court for the Southern District of Florida at 11:17 a.m. on a Thursday morning. By noon, it had been reviewed by a federal clerk. By 2 p.m., the Broward County Sheriff's Office had been formally served. By 4 p.m., 3 television news vans were parked outside the substation on Palmetto Park Road. Schwartz, sources inside the department would later confirm, was in a closed-door meeting with county legal counsel when the first camera crew arrived. He had not brought his own attorney yet. He should have started sooner. The federal civil rights complaint had named Schwartz individually, but Diane Osei had built the filing with a wider frame in mind. Individual liability was the entry point. The pattern was the case. The discovery request landed on the Broward County Sheriff's Office 12 days after the complaint was filed, and what it demanded was specific. Every traffic stop Schwartz had conducted over the preceding 4 years, complete with location data, driver demographics, stated justification, and outcome. The county's legal team pushed back on timeline. A federal magistrate overruled them in a single paragraph. The records arrived 14 business days later on a hard drive that Osei's team began processing the same afternoon it was received. It took her analysts 72 hours to build the complete picture. It took considerably less time than that to understand what they were looking at. 847 stops. For years. 11 of the wealthiest residential corridors in Broward County. The same neighborhoods where Schwartz had spent his career performing what he described in departmental reviews as proactive community patrol. In that entire 4-year period, across all 847 stops, not a single one had resulted in a criminal charge. Not one arrest that proceeded to prosecution. Not one case file forwarded to the state attorney's office. The stops had produced nothing legally actionable because there had been nothing legally actionable to find, a fact that had apparently not discouraged Schwartz from continuing to conduct them at a rate of roughly 4 per week. Of those 847 drivers, 89% were Black or Hispanic. The statistical analysis commissioned by Osei's team, authored by a University of Miami criminologist who had testified before Congress on discriminatory policing, concluded that the demographic concentration was so pronounced it could not be explained by any race-neutral variable available in the data. Not time of day, not vehicle type, not neighborhood crime rates. The only consistent predictor of who Schwartz stopped was who Schwartz stopped. The criminologist's report used a single phrase that would be quoted in every major newspaper that covered the case. A mathematical impossibility under any model of neutral enforcement. Osei added the analysis to the complaint as Exhibit F. It ran 41 pages. Every one of them held. The footage went national on a Friday, which meant it had the entire weekend to burn. A local Miami television affiliate ran the first edited package on Thursday evening. 90 seconds of synchronized 4-camera footage, Schwartz's radio audio laid beneath the visual, the timestamp discrepancies visible to anyone watching. By Friday morning, a national cable news network had picked it up. By Friday afternoon, it had been viewed 11 million times across platforms. By Friday evening, it had a name. Commentators, journalists, and several sitting members of Congress were calling it simply the Broward Stop, the definitive article doing the work of conveying that everyone already knew which one. The calls to Diane Osei's office began the following Monday. Not media calls. Those had started Thursday. These were different. These were people who gave their names carefully, spoke in measured sentences, and described encounters with Robbie Schwartz on quiet Broward County streets that bore a structural resemblance to what 4 cameras had captured on Palmetto Park Road. A retired educator stopped twice in the same month outside the same grocery store. A physician ordered from his vehicle in front of his own home. A contractor whose tools were searched on a pretextual inspection that Schwartz had logged in his official report as a consensual conversation. 41 people contacted Osei's office in the first 2 weeks. 38 of them were Black or Hispanic. All of them had been stopped in the same 11 residential corridors that appeared in the discovery data. Osei filed the class action motion on a Wednesday morning. By Wednesday afternoon, Broward County Sheriff's Office issued a statement announcing that Deputy Schwartz had been placed on administrative leave pending an internal review. The statement described the decision as procedural. Nobody described it that way for long. 11 days after the administrative leave announcement, following a closed session of the county commission that lasted 4 hours and generated no public statement until it was over, Robbie Schwartz was terminated. His personnel file, obtained through a public records request Osei filed the same afternoon, noted the termination reason in the clipped, institutional language bureaucracies use when the full truth is too large to fit in a single field. Conduct unbecoming. Pattern of policy violation. Loss of public trust. 11 years. 847 stops. That was all it said. The criminal trial opened on a Tuesday in March, 8 months after Schwartz had tapped on the window of a white Mercedes and made the decision that would define the remainder of his life. He was charged on 6 counts. 2 counts of filing false police reports, 3 counts of civil rights violations under federal statute, and 1 count of official misconduct. He entered the courtroom in a gray suit without his badge, which he had surrendered the day of his termination, and took his seat at the defense table with the careful, reduced posture of a man still adjusting to the experience of being the one who had to sit down and wait. The prosecution called 31 witnesses over 9 days. They came in one at a time, the retired educator, the physician, the contractor, and 28 others whose names had accumulated in Diane Osei's office across those early weeks after the footage went national. They described their stops in precise, first-hand language. The pretextual justifications, the dismissal of identification, the searches conducted without consent, the reports filed afterward that bore no resemblance to what had actually occurred. Several of them had kept records at the time. 2 had their own dashcam footage. 1 had filed a complaint with the department 3 years earlier that had been closed without investigation in 11 days. The University of Miami criminologist took the stand on the 7th day and walked the jury through 41 pages of statistical analysis with the patience of someone who understood that the numbers needed to be felt, not just heard. He demonstrated, using Schwartz's own documented stop records, that the demographic distribution of his enforcement activity could not be reproduced by any race-neutral model under any analytical framework the field recognized. He used the phrase mathematical impossibility twice. Both times, the courtroom was completely silent. The defense argued for officer discretion, community safety, and good faith judgment calls made under pressure in the field. The argument consumed 2 days and moved nothing that the 4 cameras and 41 pages of data had already settled. The jury deliberated for 3 hours and 40 minutes. They returned guilty verdicts on all 6 counts. Schwartz sat very still when the foreperson read the last one. He did not look at Christina Baca, who was seated in the gallery in her navy blazer, both hands folded in her lap, watching the proceeding with the same composed attention she brought to every courtroom she entered. The civil settlement was reached on a Thursday morning, 6 weeks after the criminal verdict, in a conference room on the 14th floor of a federal building in Miami. No cameras. No gallery. Just attorneys, a mediator, and the measured finality of numbers being agreed upon after everything else had already been decided in open court. $40 million. The full amount Diane Osei had put in the original complaint on a Thursday morning 11 months earlier, when 3 news vans were just pulling up outside a Broward County substation and Robbie Schwartz still didn't have his own attorney. The county did not admit wrongdoing in the settlement language. They rarely do, but the figure itself, unredacted, entered into the public record, reported by every outlet that had carried the 4-camera footage the previous spring, communicated something that carefully negotiated legal language never quite manages to say directly. Baca announced what she intended to do with it 4 days later, in a written statement released through Osei's office. There was no press conference. There was no podium. There was a single document, 3 paragraphs long, that said what it needed to say without elaboration. The full $40 million would fund the establishment of Florida's first fully independent law enforcement accountability commission, a permanent, civilian-led oversight body with the authority to investigate complaints, audit departmental stop records, and refer findings directly to the state attorney's office without requiring the cooperation of the agencies being reviewed. It would be staffed by civil rights attorneys, forensic statisticians, and community representatives. It would be called, at the insistence of the commission's founding board, the Baca Accountability Initiative. She had declined to attend the naming ceremony. She had a docket to return to. That was the part of the story that received the least coverage and perhaps deserved the most. Christina Baca went back to work. She put her robe back on, took her seat on the elevated bench of the 17th Judicial Circuit, and resumed doing what she had done for 17 years, presiding over the cases that came before her with the same measured authority that had held steady on a Broward County roadside when everything around her was designed to make her feel small. The first case she heard upon her return involved a wrongful stop complaint filed against a municipal officer in Palm Beach County. She ruled in favor of the plaintiff before noon.